Employer's duty to consult before redundancy. Your employer would normally be expected to consult with you about the possible redundancy before it takes effect and to consider alternatives. For example, if there are any different roles you could undertake. In the current circumstances, the employers are sending the employees on furlough instead of making them redundant. However, what would happen once the scheme stops? The government will not pay anymore, and it then depends upon your employer. The employer should follow a fair process in selecting which staff are to be kept on and which are to be made redundant. Failure to follow a fair process may result in complaints of discrimination and unfair dismissal. A failure to follow a fair process might mean that the redundancy is unfair. An employee can bring unfair dismissal claim if he or she has minimum of 2 years employment. For discrimination complaints and automatic unfair dismissal, there is no requirement of minimum period of employment. The consultation should include ways of avoiding the redundancies, reducing the number of employees to be made redundant, and reducing the effects of the redundancies. The employer must carry out meaningful, genuine consultation with a view to reaching agreement with appropriate representatives on these issues. This duty applies even when the employees to be made redundant are volunteers. Consultation should begin in good time and be completed before any redundancy notices are issued. If the employer is considering making 20 or more staff redundant at the workplace, then additional rules about consultation may apply, including collective consultation with representatives of the affected employees. The duty is to provide specified information and consult with unions or employee representatives about ways of avoiding or reducing the number of dismissals and mitigating the consequences. The process must start in good time and at least 30 days before the first dismissal and 45 days before if 100 or more dismissals are proposed. Employers will need to bear in mind that the process may take longer than usual where staff are furloughed and therefore where they do not have union representatives or standing employee body for consultation purposes. It may be prudent to start planning for the election of representatives earlier rather than later. There are significant financial penalties for non-compliance, potentially 90 days pay per affected employee where the employer has failed in its duty to consult. In the next video, we will look briefly at redundancy related payments.